You open this door with the key of reason. Beyond it is another dimension. A dimension of truth. A dimension of freedom. A dimension of joy. You're moving into the land of both the ideal and the real, of the possible and the actual. You've just crossed over into the Capitalist Corner.
Where reason meets reality, welcome to the Capitalist Corner.
Welcome to the Capitalist Corner, everybody. I'm your host, Michael Liebowitz. We've got the great Jim Valliant with us today for a great discussion. Later on today, I'll be releasing an episode of The Rational Egoist, dealing with overcoming the search for approval from other people. I thought it was a very good conversation with a licensed clinical therapist, clinical social worker. He's been so for 50 years. Very, very, very good discussion. Persephone, I can't do it. Can you please, when it goes up on X, just share it and share it with Mark? So today, Jim, we're going to talk about, it occurred to me that a lot of the sort of discussions that are taking place, the current debates, people seem to not really know the parameters of the discussion. For instance, when you're talking about the Constitution, what method of interpretation are you giving to it? So I thought you and I could have a nice discussion today. And of course, I have bombarded you with articles this morning. I hope you were happy with that. We've read the Constitutional Convention debates, the Federalist Papers, the contemporaneous whatever they are, definitions from the time. So I think we're well informed to have this discussion, but I do want to address something first. So Rosie Ginsburg, I don't know, maybe a week ago, released a statement where he disagreed with my political party and Mark's political party, the American Capitalist Party, stance on the war in Iran. That's okay. People are free to disagree. I find that very helpful, actually. It helps to clarify positions, helps me to sharpen my own thinking, correct myself when I'm wrong, which, of course, I know may be hard to believe, but I am sometimes mistaken about things. So that was fine. He also chose to then compare us to the Libertarian Party, which I thought was kind of a cheap shot, mocked our memes, which, whatever. But then he had Mark on, and I thought that would clear it up. And Mark... Mark offered me to debate with Rosie, and Rosie refused, and he said, no, Jim Valliant's going to do it. So Rosie did have Mark on. They discussed it. I had Jim on for a debate, and I thought, okay, well, we've got our positions out there. We're friends. We don't need to continue bickering back and forth in public. So then today on Race Jacobson's Facebook page, Race made a post where, Race, you're wonderful, but you're wrong about what you said, but it's fine. Race said something people need to understand and appreciate about Michael Liebowitz and Mark Pellegrino. As chairman and vice chairman of the American Capitalist Party, a political party founded on constitutional integrity and American moral principles, they must stand by the Constitution and the political principle of constitutional integrity. This is their mandate, regardless of how they or any of us feel about it. That's not really putting it right, Race, because we don't stand by the Constitution because it's our party. It's a part of our party because we believe in it. So there's a subtle distinction. So anyway, so Rosie responded 4 hours ago today. Race's post from 2 days ago, and Rosie said, the Constitution is flawed. If the party being founded on, quote, constitutional integrity, unquote, means they have to put other people's flawed ideas above reality, that is their error, and their unfortunate stance on the war is a correct application of a wrong principle. Okay. So first...
may I just say something there? I really strongly disagree with Rosie there. I mean, if we have a clear understanding of the Constitution, and if that's the way the Constitution is understood, we must obey it, whether we like it or not. That's a failure on his part to understand the importance of the Constitution and how the Constitution is the governing document. All officers of the United States take an oath to the Constitution, Constitution. It is the governing law, and whether anyone likes it or not, compliance with that is not an option for an American policymaker.
Right.
Full stop.
Okay. So my response to Rosie was this: if I am making an error, you should be able to prove it. You keep saying it, but that's all. You should be willing to publicly debate me about this. Stop making public judgments and accusations you aren't willing to defend. Because remember, Mark gave him the option to debate me, and he said no. I just saw now that Razi responded. He said, I've been defending my position on live streams for nearly 50 hours since the war started and for years before. I don't agree with you on the importance of debates, and I made a substantive point in the comment you're replying to, which you're ignoring. Okay, Razi, that was not a substantive point. That was a drive-by accusation without any proof offered. I'm fairly confident, Razi, that you've never even read the United States Constitution. I don't know what part of it you're referring to as flawed. But if you're referring to Ayn Rand's criticisms of the flaws, I assure you they were not directed at the separation of powers and the checks and balances embedded in the document. You know, you say that debates aren't important. Okay, that's fine. You can say that all you want. But you then should not continue to publicly criticize your friends if you're unwilling to engage them. That's my stance. I don't really want to talk anymore about it. I'm willing to debate Razi, or for that matter, anybody else on the issue.
Well, see, when I debated you, I was debating the morality of the policy and the merits of the policy. And you know that I believe that because the Constitution has been, in so many different ways, been misinterpreted, especially over the last century, that I kind of have to do a split screen analysis. The merits of the policy over here and the Constitution over here. That does not diminish the fact that even the flawed parts of if we're going to have a rule of law, that means that we go with even the flawed parts. So if the United States Constitution, for example, let me just pick an arbitrary example, the post office, clearly under the Constitution,
yes,
Congress has a power to create a post office.
I don't like it.
I don't like it. The government shouldn't be involved in post office, letter delivery, or any such thing. On the other hand, I have to concede that the post office is constitutionally authorized. So even the bits that are flawed, even the parts that I don't like, I have to swallow if I want to live in a system of a rule of law. As a lawyer, you know, working for many years as a lawyer in this country, though, I mean, I remember going all the way back to law school. I would, I would have arguments with the right about rights, with the left about the powers, and I was this weirdo. As one of my professors said, you know, that weird, he's misidentifying me as a libertarian. You know, he was saying, who approves of this? Who disapproves of it? I'd I'd be the only one in the whole class raising my hand, apart from that weird libertarian over there who agrees or approves with this. I was used to that, and I was used to dealing in a world, a constitutional order with which I totally disagreed. On the other hand, I recognize the Supreme Court is part of that constitutional order. Right. And Marbury versus Madison settled the Supreme Court's role in this a long time ago. And if I believe in a system of rule of law, then I also have to submit to that's one of my tests for Mr. Trump. Does Mr. Trump submit to the Supreme Court's decisions on these things? Because after all, they decide cases and controversies that come under the Constitution, yes, according to Article 3 of the Constitution. So it is, even if we don't like it, even if it's flawed, Mr. Ginsburg, we have to comply with it in the United States because we are governed by laws, starting with the Constitution, not men.
Yeah, and by the way, the rule of law is not a principle above or separate from reality. It is absolutely rooted in the reality of human beings and governing structures, which is why we need the rule of law. And the Constitution, for all its flaws, the separation of powers and checks and balances are vital so that we don't end up in a dictatorship. And the rule of law is vital to avoid arbitrary power on the one hand and anarchy on the other. Gary Menard has given a $9.99 super chat. He says a very important issue, most especially to Israelis, but I don't think they quite understand the integral importance of the Constitution to Americans. Unique greatness and flourishing. I think you're probably right. And so we're going to get into this. So, Jim, the first thing I want to discuss, and of course, if I mischaracterize your view or if I mischaracterize anything, correct me. Okay. There's three main methods of constitutional interpretation. The first is originalism. Now, originalism, though, can be broken down generally into two parts. There's those who advocate interpreting based on the original intent of the drafters of the document. I do not adhere to that. It is impossible to get into the subjective views of the people, especially because there were so many different views, and much of it was a measure of compromise. The other type of originalism, which I do ascribe to, is that the Constitution should be interpreted based on the meaning of the text at the time each part of it was adopted. So if we go to the main body and the original Bill of Rights, the first 10 amendments, it would be the founding generation. If it is the 14th Amendment, then we should look to the generation that ratified it post-Civil War, etc., etc. There is also the idea that the Constitution is a living document. What they mean by living is that judges can interpret it according to evolving standards, to modern times. They're not bound by what the document says or meant. They go by what they think it should mean or would mean if applied today. Finally, there's the view, and there's probably more, but the three I'm familiar with, is the view put out by Professor Richard Epstein. He calls it the prescriptive Constitution. And this, I think, Jim, is the closest to your view. Not exact, but I do think it's close, and I'll tell you why. So he says, Richard says that if something becomes long precedent, that then it should be obeyed because it's long precedent. That it's no longer, even if it was unconstitutional at the time, it is precedent. And the reason I say, Jim, that this is similar to your view is because you're saying that given the rule of law, that the Supreme Court ultimately decides, and if they have decided this way, we have to go by it. I'm not saying you mirror his or that you would use his same argument. No, I'm just saying that it's close in the sense of the respect for precedent.
As a policymaker, look, I was a deputy district attorney. I wasn't a policymaker. I obeyed the policy of the elected district attorney in my county. But whether you're a policymaker or anyone working for government, you have to comply with the Supreme Court. That is an entirely different proposition than what Professor Epstein is articulating there. I fully reject his position. If I were on the Supreme Court, if I were the one, or even on a federal court of appeals, and I was asked to interpret the Constitution, I would go by the plain meaning first and foremost. That is when you overturn. I don't care if it's 200-year precedent. Okay. I don't care if it's
okay. Hold on for 1 second. I just want to ask you, because I think that you and I are talking about two different things here. You're saying that if you were the one making the decision on the Supreme Court, you would rule these laws unconstitutional.
And that's what Professor Epstein is talking.
So that's where you would differ with him. But as a citizen,
a means of interpreting the Constitution,
he's wrong.
But I submit to the federal court's interpretation of the Constitution.
That's what I meant by similarity. I'm sorry if I.
That's the only overlap, but it's not. You see, a method of interpreting the Constitution. Because if I were a federal judge, I would be interpreting the Constitution by its plain meaning in my mind.
Yes.
I am not on the map that you laid out there, okay? Because my view of the original meaning. There's another thing is that I apply the objectivist theory of concepts to the ideas there. In other words, concepts are open-ended. They're not defined. Definitions are contextual. Definitions can change over time. The meaning of the concept is its contents and what the thrust of that content is. So when you come across a new concrete, the concept is still open-ended. So I apply both objectivist epistemology on concepts to this, but more than that, I recognize something the framers understood.
Jim, is something wrong with your volume? It seems that the audience is saying something's wrong.
Golly,
You're back. It's perfect. Okay, go ahead.
I think there's another thing that the framers built in. The framers had two perspectives on how to interpret the Constitution, and they gave us a key code on that called the 9th and 10th Amendments. And the debate over the Bill of Rights reveals it by itself quite clearly. When it comes to the powers, and this is why we're going to substantially agree today, when it comes to the powers and the procedures that are specified in the Constitution, the powers granted to the federal government, I am a narrow. Oh, there is an echo I can hear. In any case, there is I think that demands a very strict and narrow interpretation. So, for example, the declaration of war or the president's war powers, I think we need to be, although somewhat vague in the Constitution and on purpose, when it comes to things like that, the specified powers that Congress gets, the procedures under which government must operate, I read the Constitution very, very strictly and narrowly. When it comes to the rights granted to the people, I think we've been told and we've been invited by the framers to read the liberties of the people in a broad, broad way. In fact, if we don't give meaning, substantive meaning to the Ninth Amendment, we're violating the original meaning of the Bill of Rights.
Okay, so Jim, you actually are closer then to Randy Barnett because he has what he calls the presumption of liberty. So when it comes to liberty, he views it expansively, at least as of 2005, government power narrowly. Okay, so what I want to talk about today is if anybody ever wants to argue about which method is proper, that's fine, we can do it. But for today, I just want to address the original meaning of the text.
Yes.
So when we go to Article 1, Section 8, it gives Congress the power to declare war. Now, it's important to note that in the Constitutional Convention debates, it was actually originally make war. They changed it to declare war because they didn't want presidents to be handcuffed in the case of that we were under attack. So clearly, under original meaning, if we are under attack or under invasion, presidents have the right to repel that. Implicit in that idea is that if you're not under attack, you're not under invasion, he does not have the authority.
I think it's pretty plain. In Section 8, they give the Congress the power to create a uniform rule of justice, in effect, to regulate the military, but also to declare war. And they were distinguishing there between make war, because apparently presidents can and have made and created wars that later Congresses have approved of.
Yeah.
And when we mean attack the United States or invasions or insurrections, that was precisely what they had in mind. But I also think that they meant more than just on the borders of the United States. So that if Americans are attacked abroad, can presidents act abroad? Absolutely. That's an attack on America, attack on Americans, and Congress can't be summoned. So whether it's here at home should not be the limitation. But on the other hand, it should be some kind of attack on America or Americans. It should be some kind of emergency. Let's put it this way. It should be an emergency situation that the president is responding to. He can make war when America or Americans are under immediate attack and Congress can't be assembled. The idea is, back in those days, it could take weeks for Congress to assemble but, back in the 18th century. And they didn't want a president to have to wait for Congress to do that. At the end of Section 4, Article the 4th, as we would call it, of the body of the Constitution, it says that states shall be protected from invasion by the federal government, or, as they use and in the conjunctive to give two, in effect, scenarios. When states are attacked, the federal government has to protect them. And that would give the president some leeway there. Or when the legislature or executive ask for help, help us, federal government. So there are two situations where the federal government can protect, say, a state from being invaded. And then, of course, they give in Article 2 the power of being commander-in-chief to the president. Now, what does that mean?
When they are called in service.
Yeah, but what is called into service, since we've just made the distinction there between make and declare war, the president could call them into service when necessary under these emergency scenarios, and he is the commander. And even after a declaration of war by Congress can't step on the president's ability to command the forces. He decides the strategy. He decides the tactics. He fires and hires generals. And that is his scope of plenary power, and that cannot be touched by Congress. So the president does have plenary power over military and foreign policy under Article 2. Bear that in mind. Also bear in mind that it is the emergency situation. I have to agree completely with you here. There's no question when you read the Federalist. Hamilton and Madison both addressed this question, and it seems to be pretty clear that it's only under these emergency situations where Americans are being attacked that or in danger of being attacked. I don't think we have to wait for an actual bomb to hit us. If someone's shooting at you or threatening incredibly to shoot at you, but it has to be this kind of emergency situation. And so you'll notice that in the pre-Civil War period of American history, you've got Thomas Jefferson starting a war with the Barbary pirates and only then getting congressional approval afterwards. Or James Madison really maneuvering us into the War of 1812 and getting congressional authorization. Or James K. Polk, sort of, Lincoln complained that Polk kind of maneuvered us into a war with Mexico, but Congress once more gave the green light. And so before the Civil War, when it comes to waging war, presidents would often initiate the conflict, if you will, but then get congressional approval afterwards.
You know what's interesting to me, Jim, is back when it was very difficult to summon Congress, they actually went to Congress more often. In the modern era, when it's relatively easy to get them together, they don't.
But if you go the further back in time you go, the better our politicians were at interpreting the document and sticking to the true constitutional order, I think. And the further back in time you go, for the poor 14th Amendment, for example, after the Civil War, was basically gutted right out of the chute by the Supreme Court. In the slaughterhouse cases, they knocked out the Privileges and Immunities Clause, making it meaningless. By the 1890s, they were doing Plessy versus Ferguson, basically neutralizing the Equal Protection Clause. So the poor 14th Amendment was gutted by the Supreme Court almost from the outset.
Yes. All right. So one of the problems, well, I want to get into war. I don't want to get into war. I want to talk about the concept of war. So pivotal to this discussion is, obviously, we're looking at the modern context and with this conflict with Iran, and I've heard various people say that this is not war. Now, if you go by, first of all, the statements from the administration, it's the Department of War now. They clearly think it's war. But if you go and believe, and listen, I've done as deep a dive as I could do into the original definitions and meaning of war, from Vitali, I think his name is, or something along those lines. Samuel Johnson, a guy with a horrible name, Richard Byrne, his dictionary. I've looked at so many different definitions of what war was at the time, including ChatGPT, Claude, and other ones. And it's clear that war is armed conflict between two nations, two sovereigns. And that's clearly what we have here.
I think there's certain definitions that'll say nation or state. And they're distinguishing between a governing entity or body. But there have to be two governing bodies in a state of actual violence with one another, or preparing to go to at least violence to one another, or it's not war.
Yeah, so there's a few historical precedents, and of course you jumped the gun and got to them, that people have brought up. One was the Whiskey Rebellion, and that Washington put it down. The problem I have with that analogy right off the bat is that it was not a foreign conflict.
Yeah.
It was a domestic,
rebellion.
It was a domestic rebellion. And Washington was already given authority by Congress to address this.
Well, but we
that
constitutional? The same thing about the war powers.
No. We're going to get to that too. My point is that they did pass something. Now this. I'm going to maybe bring in too much here. If I do, that's fine, Jim. You'll be good at picking it apart. But numerous people have cited physical precedent. What I mean by physical precedent is the fact that people have done it. They've gone to war, and they say, look, if it was unconstitutional, why would they do it? Well, here's the problem. It seems pretty clear to me that the National Bank was unconstitutional. That was put into place immediately, in the first administration. It seems that the Alien and Sedition Acts were very questionable constitutionally. Adams did it. The Louisiana Purchase, Jefferson thought it was unconstitutional and did it anyway.
The problem there is that there is a section of the Constitution that talks about territories of the United States that aren't states.
Right.
So the president has the foreign policy power. So theoretically, one could have argued, but Thomas Jefferson didn't.
No. My only point here is not whether it is or not. Is Jefferson firmly believed it wasn't constitutional and did it anyway.
Yes.
And then when Madison was president, after spending so much time in vitriol arguing against the bank, he rechartered it. So the fact that flawed humans have violated the document before doesn't mean that
at least
things were
with the Bank of the United States, there was controversy within the framers about the degree of what does this power to issue currency is. And Hamilton, we did stray beyond what he was saying in the federal.
I think we did. Can I tell you why? And then you can tell me I'm wrong.
Sure.
Prior, in the Federalist Papers, Hamilton argued that if a power is not granted to the government does not have it. When arguing for the bank, he said, if a power is not forbidden to the government, they have it.
Trying to reassure us that we didn't need even but he was one of those guys who said we don't even need a Bill of Rights because I read the powers narrowly. Well, it turns out he didn't read them so narrowly when it came to practice. But it did happen really early on. That is to say, the Washington, Hamilton, that generation gave us the first Bank of the United States. When it comes to the Alien and Sedition Acts, we have something much more clear. I mean, Madison's report of 1800. Look,
that Virginia and Kentucky resolutions as well.
Yeah, exact. Oh, yeah. But the point is, Madison was quite clear. He says, that the Alien Friends Act is clearly unconstitutional. There's no power to regulate.
Well, you had to bring us into the weeds with that one, didn't you, Valliant? The Alien
Friends. But the point is that Madison was really clear about there's no general power to regulate immigration. So this Friends Act or Alien Friends Act is clearly in his mind unconstitutional. What's interesting is the Alien Enemies Act is still law of the land.
Yeah. And I think it's good law, by the way.
And the Sedition Acts that went with it, they just flat violated the First Amendment. And Supreme Courts, although they have never had an opportunity because they lapsed, they've never had an opportunity to overthrow them. But many a Supreme Court opinion has said, if it came up today, that would be unconstitutional under the First Amendment, which is a much better analysis of the First Amendment in my mind.
Yeah, and a problem with this instance is the Supreme Court has never ruled on these cases of the president going to war. The problem has to do with standing. Because in order to get in front of the Supreme Court, you have to put in for a writ of certiorari. And in order to demonstrate standing, you have to demonstrate that you personally have been harmed.
You have an interest. You have a stake.
Right. So as an American citizen, you can't just go and say, okay, I'm a citizen. They're violating the Constitution. I'm bringing suit.
Well, the Supreme Court are the folks who decide who has proper standing and what standing is under these questions. So who's got standing? So, for example, when it comes to, say, certain immigration laws, do states have standing? When it comes to welfare laws, do state Supreme Court say, states have standings. Individual citizens, hey, wait a minute. As a taxpayer, don't I have standing every single time the federal government spends money? Supreme Court says, just. No, just because now wait a minute. I am a party in interest. I am being ripped off. And the Supreme Court says, no, you qua taxpayer do not have standing to complain about some welfare law that we passed. Wait, what? So the Supreme Court decides who's got standing is one of the main issues here. And that's one of the key issues in, presumptive issues as you walk in the door, who's got standing. And the Supreme Court has long said, when it comes to standing, and look, I was drafted into the Vietnam War, you might say. Don't I have standing over what the war power? No, I'm afraid not. Now, it seems to me there's really clear cases where people have an interest at stake. And that's how they define it. You don't have standing unless you're a party at real interest. Okay, a party at real interest is woo. I would think soldiers in time of war would have standing if that concept makes any sense at all. Yeah. But no. The Supreme Court itself defines standing and who's got it and who doesn't. But no, and the other thing that's important to know here is that presidents have not wanted the Supreme Court to decide this. Presidents are the ones who decide what the position the United States government will take before the Supreme Court. Presidents appoint the Solicitor General, and it's the Solicitor General who argues the government's side of the case before the Supreme Court. And so have presidents wanted clarification from the Supreme Court? No. In modern time, not in my lifetime. Every president has claimed, for example, much broader authority than you and I think actually exists under the Constitution. They claim that as commander-in-chief, they can do these things. They can start a Korean war. They can invade Grenada. They can do what Obama did in Libya. You bet we can do this. We're the president of the United States. And rather than rule on the War Powers Act in that sense, the government of the United States has been reluctant to have the Supreme Court decide such cases. So both there's a standing issue and a reluctance on the part of the chief executive to have his own war powers defined by the Supreme Court. But I also think there's a third issue here. when you read cases and you become familiar with cases on foreign policy and military policy, you get one big message coming through from the Supreme Court. We don't want to get involved in those kind of things. That's between Congress and the president. We're not going to micromanage foreign or military policy. That's left to the policy-making branches of our government.
And it
But
seems like
all
Congress,
three of those elements are at play.
right? And it seems, that Congress, they get the best of both worlds because they can either praise or criticize a given war without having to take responsibility for it. The president gets the authority that he wants, and the Supreme Court gets to avoid the question all around.
Well, and I would point out that the Senate just failed to pass a war, a restriction on the president's
Well,
powers.
interesting though, if had Republicans gotten rid of the filibuster like they've been talking about doing, that might be a case of careful what you wish for. I believe they got 53 votes in the Senate, but they didn't reach filibuster. They didn't reach cloture with the 60 votes.
No, but the Senate did reject. In effect, they called upon, but the point is, you'd also need, let's say it does pass the House today, and let's say the Senate had done something different yesterday, it would still go to the president for signature, and they'd need 2/3 of each house to overcome a presidential veto. So it's very hard, in effect. Now, the Senate did reject this attempt to thwart Trump. So that says something. On the other hand, it would have been really hard because the Congress has put themselves into this War Powers Act box. But it does serve their political purposes, as you pointed out. They can have their cake and sort of eat it too. They can oppose the war, but look, if the president notifies you that they're doing this, they've got at least 60 days to basically do what they like. But remember what Obama did was really, and this is where Democrats are just despicable beyond belief. You asked Nancy Pelosi, 12 years ago. So what you're saying, Madam Speaker or Madam Leader, is that the president doesn't need congressional authorization to do month after month after month war in Libya that takes out the dictator of Libya.
Regime change.
She said regime change that lasted a lot longer than 60 days. And she said that Obama did not need congressional authorization. Right. So these same damn Democrats who are saying that it's unconstitutional. So the American Capitalist Party, I hope, trust, and believe, because I know the people involved, would not be the effing hypocrites that the Democrats are on this issue. They can't be trusted because it depends on who the president is. Right. But the same is true of the Republicans. It depends on who the president is there. Oh, this is Obama, and this is going past the 60 days.
Well, Mark Levin has been arguing for originalism as long as I've been paying attention. And now he's saying it's constitutional illiteracy to think that the president under the original Constitution doesn't have this power. So,
I read the powers, as I say, I read the powers narrowly. I read these things narrowly. And so I will definitely consult the Federalist Papers and stick right to what Madison and Hamilton are suggesting.
Well, even Madison, by the way, I mean, in the Helvidius Pacificus debates where they were debating about whether to get involved, I believe, in France, where Madison was I think Madison might have been, I don't know, it doesn't matter, but Madison argued very strongly that the president cannot declare war, and even Hamilton conceded that. He just was, a stickler for if you're attacked. So there's plenty of evidence along that. But now you mentioned the War Powers Act. If I get it wrong, Jim, just tell me. But I believe that the War Powers Act requires the president to consult Congress before even acting. He has to consult, and that has to be a real consultation. At least it's supposed to be. Somehow they've gone from consulting Congress to notifying a gang of 8. I don't know.
Well, what counts as, but there has been an official notification under the War Powers Act. And consult, has he been talking with Lindsey Graham and Tom Cotton? I mean, what do we mean by consult? If he's talking with the top senators on the Armed Services Committee, does that count as consult? Because he sure the heck has been talking with, what are called the hawkish Republicans in the Senate for a long time about this. In fact, this is not the first time we've gone to bat with Iran. Remember, I mean, we did in the 12-day war. It was a much more limited thing, but we dropped some powerful bombs on Iran. So there's been communication about this issue going on for some months, and certainly within his party. that probably suffices for consult. And, even if you notify the Gang of Eight, that might well qualify as notify. But the president has gone to he did an official briefing with members of both parties, and that does qualify under the War Powers Act. So I think under these circumstances, but you make another, when you bring up things like standing, who the heck is going to complain and who the heck is going to bring this to court for the Supreme Court to interpret the War Powers Act and what that requires the president to specifically do? I don't see that being challenged and brought to the Supreme Court anytime soon, any more than the Supreme Court would want to touch it with a 10-foot pole. But on the other hand, I think that the War Powers Act has probably been complied with. Let me put it that way. And I think that probably does give the president at least 60 days from the time it began, even with what is obviously a major war going on. I don't know who's playing with the word war. That kind of disturbs me right there. But whoever's playing games with the word war, tell me with a straight face that this is not war. I mean, Americans have died and Iranians have died and bombs are going off. So
Ian Gilmore says the War Powers Act notifications are intended for non-war hostilities. I'm looking at this right now, Ian, and it appears that it's also intended for non-war hostilities, not only.
No, it's the use of it's the president's independent use of the military in just about any context you can imagine. But the limitations on it are the notify Congress, and then that puts you on a time leash for Congress then giving it its thumbs up or thumbs down. It is, from the perspective of true constitutionalism, it's not just the way we narrowly read the Constitution. On these sorts of matters, it's a separation of powers issue. Can the Congress so delegate that kind of broad authority to a president of the United States? I think that's a serious question. Separation of powers was foremost on James Madison's mind. You can see it in the very structure of the Constitution. Article 1 creates, establishes, and defines the Congress and its roles and power and procedures. Article 2, the president. Article 3, the federal judiciary. Article 4, the relation with the states. Article 5, the amending of the Constitution. So the way they structurally laid out the Constitution itself reflects Montesquieu's idea of separation of powers, something that James Madison specifically was influenced by and defended as critical. And so there's a separation of powers issue. Is the War Powers Act, designed in the midst, mind you, in the wake of the Americans' rejection of the Vietnam War, designed in their minds to limit a president's power, does it, on the other hand, forget its intention to limit a president's power, does it in fact violate the separation of powers in the sense that Congress can't even give that much power to the president of the United States?
I believe it does.
That would be the way I would frame the issue there.
You know, I want to get into how do we get back to constitutional government, but I want to just point something out. And this is probably the heart of the problem. And it's not just politicians, mind you. It seems like it's everybody. Everybody loves the Constitution until they want to do something that it doesn't allow. Randy Barnett in Restoring the Lost Constitution points out that if you read the Constitution and like everything in there and think that it never disagrees with you, you're probably reading it wrong. It's not about what I think is right or what I think is wrong. Like people are saying, well, I've heard this claim. Well, what if Congress doesn't act? What should the president do? The problem with that framing is that you're saying that the president then gets to decide, in contrary to Congress, and that might sound great when when it's a full blistering war coming, but when it's invading Greenland, maybe not so much. And that's the problem if the president gets to decide. But Jim, when so many people, politicians on every side, invoke the Constitution when it's convenient, the American people seem to do the same. How can we ever hope to restore a constitutional republic?
Oh man, this is the $64 question.
$64. That's it.
Well, $64,000, $64 million. What do you want?
Okay, because I'd pay the $64. I'm just saying.
Yeah. Okay. No, but it's the key question here. The Constitution is being interpreted in ways that are absolutely pernicious to any correct reading of the Constitution. You know, the Supreme Court, when it comes to rights, for example, your freedom of speech, your freedom of religious practice, that's given what they call strict scrutiny, as opposed to, say, property rights or economic liberties, which only have to face a rational relation test. Where is that in the Constitution? Is there anything in the Constitution that says, well, this stuff is really fundamental and this stuff is less fundamental? No, you have to read all of the Constitution. Each provision has to be given the same weight, the same power, and each has to be interpreted in light of all the others. That's the only sane way of going about this. But the Supreme Court has made up a whole regime of methodological interpretation when it comes to rights that is outside of the Constitution. They made it up all on their own. It's like them getting to decide, immunity. You know where governmental immunity really comes from? It originates in a Supreme Court decision that said, guess what? Government officials have to have some kind of immunity. So the Supreme Court is perfectly happy. Immigration laws. Back in 1875, when Congress passed the first comprehensive immigration regulation, Supreme Court just gave it the green light. And did they cite any provision of the Constitution?
No, they invented it.
They said, well, all of the nations in the world, every nation in the world does it, so therefore America must be able to do it. That's nothing to do with the Constitution.
Right.
Or the way the Commerce Clause. Do you realize today that most criminal law, that sure, they've got a power to enforce counterfeiting laws. Absolutely. They have a right to create and enforce a code of military justice on members of the military. Absolutely. That's clearly in the Constitution. But you know something? What about the RICO statute that goes against organized crime? What about the Drug Enforcement Agency? You know, all of that is based on a wildly out of whack interpretation of the Commerce Clause. The Commerce Clause gives them this authority to have a Department of Education, all these. Think of it. Most of the government that we have from the federal government is predicated upon a twisted view of the Commerce Clause. It really didn't change dramatically until the 1930s. It was already under assault. Between the 1920s and 1930s, it was chipping away and eroding. But by the 1930s, around 1936, the Supreme Court was totally changing what the Commerce Clause actually meant and making in effect the Congress the economic dictator of the United States. Anything could practically be justified thereafter if Congress gave some rational reason, some rational relation between this and commerce. But look, on the other hand, the quote you have is fantastic there. The Supreme Court said you can't do an income tax. And so what did they do? They passed an amendment. There's an amendment to the Constitution that gives the federal government the power to tax income. I think that is horrific, pernicious, awful, but guess what? It's constitutional, whether I like it or don't like it. When they passed prohibition, an amendment, that outlawed alcohol. What a stupid ass law that was.
Jim, I want to just read. Cuda Baba talks about the General Welfare Clause. This is Madison on that very clause. He says that.
It's a limitation.
He says,
not a grant of power.
He says, it has been urged and echoed that the power to lay and collect taxes, duties, imposts, and excises to pay the debts and provide for the common defense and general welfare of the United States amounts to an unlimited commission to exercise every power which may be alleged to be necessary for the common defense or general welfare. No stronger proof could be given of the distress under which these writers labor for objections than their stooping to such a misconstruction. Had no other enumeration or definition of the powers of the Congress been found in the Constitution, then the general expressions just cited, the authors of the objection might have had some color for it, though it would have been difficult to find a reason for so awkward a form of describing an authority to legislate in all possible cases. A power to destroy the freedom of the press, the trial by jury, or even to regulate the course of dissents, or the form of conveyances, must be very singularly expressed by the terms to raise money for the general welfare. And by what color can the objection have when a specification of the objects alluded to by these general terms immediately follows and is not even separated by a longer pause than a semicolon?
Now think about what he just said there. We just, in Article 1, Section 8, listed the powers that we gave to
Right.
Congress. If the General Welfare Clause could be interpreted to be something else, why would we have gone to the trouble of giving you this specific list? No, the specific list of their powers. In fact, the way to understand the phrase general welfare or general defense and general welfare, it says you can raise, it's in the tariff, it's in the tax raising part. They're saying you can raise tariffs only for defense and what we're about to give you, which is the concrete definition of what the general welfare allows you to do. So it's a limitation on the power to raise tariffs and excises. It's not an independent grant of power. And it was not until 1936, I believe it was the Butler case, where talk about corrupt interpretation of the Constitution. In the 1930s, the Supreme Court completely reversed direction, ignored everything Madison said there, ignored every rule of legal interpretation. What a brilliant legal mind Madison was. If you're going to read a legal document, you have to read it properly. Okay? The Supreme Court in 1936 chucked out Madison, all principles of proper legal interpretation and construction, and said that the General Welfare Clause was an affirmative grant of power. So between this corrupt view of the General Welfare Clause, which is meant to be a limitation on the power to raise tariffs and excises, frankly, that limits how they can raise tariffs and taxes, not grant power, but consider it. The Commerce Clause and the General Welfare Clause, starting in that very same period, 1936, 1937. And since then, guess what? The Congress of the United States has effectively become the economic dictator of the United States. And they can do anything, in effect, they want. If they want to, and things we might like you say, you might think, hey, it's great to have an FBI, a Federal Bureau of Investigation that has kidnapping laws, that could go after organized crime. But guess what? It's not in the Constitution. And no proper interpretation of the Constitution, in my mind, could support it. Consider this, ladies and gentlemen.
Wait, we got to give something first. Got to give a shout out. Jason Adams, $4.99 super chat. He says, practice your 21st Amendment. Whiskey for my men, beer for my horses.
Well, thank goodness we got rid of prohibition. It did not work. Let's put it this way.
Well, note, though, that they at least thought that it required an amendment.
That's true. They understood that they had a much better appreciation in those days for the limited powers that Congress was being granted and government was being granted. You know, consider the Federal Communications Commission, ladies and gentlemen.
Do I have to?
Well, I know, but we've talked about how, in effect, it was the nationalization of broadcast air frequencies and how they have to be broadcast in the national interest. Now, wait a minute here. If the Commerce Clause could not support a post office, because guess what? We have a Commerce Clause and a Post Office Clause. In other words, to obey Madison's rules of legal construction here, we would have to say to ourselves, well, why on earth would they have to have, if the FCC can be justified under the Commerce Clause, surely a post office could have been justified under the Commerce Clause. But no, the framers felt it necessary to specify post office. So in other words, I can tell you right now, the FCC is not allowed under the Commerce Clause. That is a bizarre expansion of what the Commerce Clause means. So we have to attend to what James Madison is saying here. We have to read carefully that list of powers. That's the flesh put onto the bones of what general welfare means in that context. So like I say, the 9th and 10th Amendments are the key code, the magic decoder ring for the Constitution. It really is. When it comes to the powers granted to the federal government and the procedures under which they have to operate, we have to read that narrowly and specifically and as original intent-y as anyone. I'll do you one better and say that's exactly what they wanted and that is what must happen. When it comes to big, broad statements like freedom of speech and freedom of religious exercise and due process of law and so forth, though that's an invitation. Given the 9th Amendment, that's actually an open invitation. So to give the 9th Amendment substance and meaning, which we must do, we must give meaning to every word, every phrase, every semicolon. If we do not have an expansive view of liberty, we're violating the Bill of Rights. So I think people are getting an idea an impression of how I approached constitutional interpretation. When it comes to individual liberty, basically the government is the laboring oar, and they better the hell convince me that they have that power. Okay, I'll grant you have the power to have a post office. I'll grant you can impose an income tax because you've got specific language in the Constitution today that gives you the power to do that. Absent that, I read liberty expansively. I'm following my instructions from the Constitution itself. Make sense?
It does. And just so, to do a little advertising, Jim and I have an excellent episode of The Rational Legowist from 2 or 3 years back where we debated constitutional interpretation. I highly recommend it. Jim, can I tell you something I found humorous? You you ever read a book that you've already read and you'll see you underline things and you're like, why the hell did I underline this? It doesn't even make any sense. Why did I care about this? When I'm looking through the Federalist this morning, I knew exactly why I had underlined some of the stuff that I underlined. And it amazed me because I got that, I think, in 2000, I want to say 6 or 7, but I was much more of a hawk back then. So I was far more keen to be highlighting all the stuff about the importance of national defense, the importance of having, a robust system of defense, that sort of thing. So that is a lot of what I was underlying. It was an interesting sort of time capsule.
Well, it's really interesting. The idea of having a standing army was alien to the framers. They did not envision a standing military.
Well, you make a great point there. The idea that they would go from so many people opposing even the idea of a standing army to saying, oh, yeah, have a standing army and let the president just send them off when he wants is just, it's just ludicrous.
It's quite a leap that we've made, isn't it?
Yeah.
But
yeah.
I have to admit, though, that the creation of an army and a navy and the regulation thereof is granted in Section 8 to the Congress of the United States. They do have the power to create an army. They do have the power to create a navy. They do have a power to set the rules for those things. It's right there in Section 8, Article 1. But national defense was one of their primary concern. They thought the federal government ought to be doing a handful of counterfeiting, piracy, let's count a post office. But you can count a very narrow, specific, a rule of naturalization, a very specific and narrow list. If they have to get that granular in Section 8, ladies and gentlemen, let me suggest that over 90% of what our government does today is flatly unconstitutional by any legitimate reading of the Constitution. But That's why I have this split screen analysis. And all my life as an American.
Are you sure you're not Italian?
With my hands? I do speak with my hands a lot, I admit. But you see, there's this split screen. There's this split screen analysis that I've had to do my entire life, where I say, what is right, proper, just, constitutional over here, and how do I operate within this system, this corrupt constitutional system that has been foisted on us by both the Supreme Court and presidents and their behavior, if you will. All of the main actors, the Congress has been derelict in its duty in giving the executive branch so much power. The president has grabbed power whenever he can and avoided having the Supreme Court decide his war powers whenever possible. And 3, and most egregiously, because that's really their sole function, is, to interpret our laws and our Constitution, the United States Supreme Court. Their job description is to interpret acts of Congress and, most importantly, the Constitution itself. And they bear the brunt of the blame here. They have narrowed the scope of what proper standing is. Taxpayers don't have standing when it comes to government spending their money. Soldiers don't have standing when it comes to, the war powers, say, of the president. These are the people who actually have a real stake, a real interest in the outcome of these cases. But the Supreme Court defines, in effect, all of those things, and has done so, I think, in a way that is pernicious to liberty. And
so what do you think about this name, Jim? James Valliantini.
James Valliantini. I love it. I'm an Italophile. Okay. In Europe, my favorite place is Italy. It's like I live in California. It's not politically. They're all communists and Catholics out there, or both. But I love the art. I love the wine. I love the ruins. I love the weather. It is a garden of the world, Italy, and it has so many wonderful things going for it. A sense of style, a sense of all kinds of great Renaissance art and architecture. I love Italy, so maybe that's what's coming out. But I'm not, as far as I know, I have no Italian heritage.
So, Race Jacobson says, now that Jim has done his good work breaking up the school fight, Rozzy and Mike can finally play on the swings again. Race, while I appreciate your humor, and I do, I just want to be clear. This was not something that I initiated. It's not something that I wanted. I have liked Rozzy. I've hung out with Rozzy. I've joked with Rozzy. I am scheduled to speak at Rozzy's conference. And by the way, I have no problem telling me I'm wrong. If Rozzy had come out and said, look, I think that you're wrong and this is why, I would have been fine with it. That's fine. That's what you could do that all day. Plenty of my friends disagree with me all the time. I mean, I think you've seen that on this show. But when you could compare us to the Libertarian Party, and when you say we treat the Constitution like a Bible, or when you talk about how we're elevating the Constitution above reality, those aren't disagreements. Those are accusations. That's what my problem is. And my point is, if you're going to do that, you should be able to prove it. That's all. That's my only point. I want to be clear.
You have Rozzy on your program?
I'd have him anywhere. I would have Rozzy anywhere. I'd have Rozzy here. I'd go there. I'd go on Race's program. It doesn't matter.
You know, among Ayn Rand fans, students of objectivism, yeah, I think that we've reached a point where we have to really confront something important. The scope of disagreement that doesn't cause us to be, morally denounce, morally judge someone. Yes, of course, objectivism teaches morality begins with how we use our minds. Thinking is the source of all virtue. Evasion is really the primary vice. And so there are contexts in which, if I know your context, I can judge whether or not you're immoral, being dishonest, and even coming to the idea or not. And there are, obviously, even if I don't know your context, there are parameters. If someone came out and argued for the flat earth or was an overt Nazi or Holocaust denier, I would not debate that person. I know they're not being intellectually honest. But within that, and among people who claim to share the same basic philosophical principles and values, we have to recognize that there's only one, again, another thing objectivism teaches, there's only one right answer. Okay, it's not that I don't think the person's wrong. It's however, the range of debate where I'm not going to morally denounce this person as anti-objectivist or immoral for disagreeing with me. And that part, back in the 1980s, Leonard Peikoff denounced David Kelly and his open objectivism. I'm all for that. And in fact, sort of discussed the parameters of this. But consider how broad those parameters are. We can end up saying objectivism is much less than it is if we end up with the David Kelly open objectivist view. But let's not be in danger of saying objectivism is more than it is. That is to say, my application of objectivism. And I can't put that on Ayn Rand. That's not her doing. It's my application of what I think her ideas imply. And Michael might disagree, Rozzy might disagree. And if we're both in good faith trying to apply those principles, I don't see any reason for saying, well, you've crossed the line of objectivism and you're out. No. I think we should do just the opposite. I think it's healthy for the movement. For if there is an objectivism movement out there, a movement for objectivism, we've got to be able to accept those kind of disagreements when it comes to issues of application.
All right, Jim, now that you've done all that talking, you're ready to do a little more and give us the capitalist thought of the day? Now that this time you're not trying to relitigate the debate we just had?
No, but I do try to integrate. It's true. And I was on my mind. A little cheating in the debate, the quad debate. But I do try to integrate what we're saying
yes.
In the course of it with the capitalist thought when I am called upon to do it. And
it's your mission if you choose to accept it.
Yes, Mr. Phelps. I accept it in this case because without a limited government, without a constitutional order, we cannot have rule of law. There have to be rules. The history of England really is a history of traditions and precedents. It's not a written constitution. We in the United States are blessed, in effect, with a written constitution. And for that blessing to have its positive impact on individual liberty, we need to respect that constitution and the constitutional order. And you may think it needs to be changed, and you may have a great argument for why it needs, because there are many things in the Constitution I would want to change.
Me too.
But the point is, we have to respect the Constitution if we're going to respect the rule of law. For that has been the bulwark defending individual liberty. And do not forget, ladies and gentlemen, capitalism is the system of individual rights primarily. It's not merely a system of buying and selling and all that. It's a system protecting individual rights, including property rights, which are the way that enable us to exercise all of our other rights. That would be my capitalist thought of the day.
That was absolutely wonderful, Jim. Thank you so much. And my question to everybody today is, what is your preferred idea? How do you think the Constitution should be interpreted? That's what I want to know. How do you think it should be interpreted? Originalism, living Constitution, something different?
Or
Go to
Valiant.
YouTube. Or Valentino's
Valentiniism.
Valentini's method. Let us know. It would be great. I appreciate it. I appreciate all you, and of course, Jim, I love and appreciate you. Where can they find you, Jim?
Well, they can find me here, and they can often find me on the Rational Egos. You can also find me at that other guy's outfit over there, the Ayn Rand Center UK. See,
and they're putting on, by the way, in the Ayn Rand Center UK, they're putting on marathon coverage right now of the war in Iran. And Jim, of course, does great stuff on the weekends. He does the going through OPAR right now. So Jim is doing great stuff. They got some good stuff going on there, despite my current disagreement with Rozzi. I'm not going to slip up on that. Jim, thank you so much.
Always a pleasure, my brother.
Well, until tomorrow, everybody, remember, always check your premises. Peace.